Yeah, before we move on to the next panel, I would like to let you know that if you go to the event website, we have opened the pre-registrations for the next year event, which is going to be in Tallinn in probably May 2024. So next up is the IMGL Masterclass, which features a great singer and moderator, Dr. Joerg Hofmann.
Good morning. Hi. So, thanks for last night. It was really brilliant. How much fun we had. I'd like to invite my panelists to join me for the discussion now. What does IMGL Masterclass stand for? IMGL is a non-profit association of usually gaming lawyers, globally, more than 300 members. But it's not only gaming lawyers, it's experts in the field of gaming regulation. And we are present in more than 45 states and 33 states and territories in the US, 45 states globally. We are organizing 2 main conferences every year. The most recent one was in April a few weeks ago. The next one will be in September 6th in Zurich. It's 3 days. It's a very high-level conference, high-profile conference, which I can really suggest to consider. But now I have my IMGL members and guests to discuss this interesting topic. And now we are complete. Excellent. First, would you like to sit next to me, Andrew? I'd like to introduce my panelists to you, starting with Veerpalu. She has a long-term experience in advising local and international clients in all aspects related to corporate law, private equity, and M&A. And she is a respected advisor of high-growth companies. She also serves as head of the IT and IP Law Committee of the Estonian Bar Association, runs the tech startup Legal Clinic of the University of Tartu, well pronounced, Tartu, thank you, and serves as co-organizer of the Estonian Legal Hackers Meetups. She earned her PhD in IT law, researching relative challenges in relation to blockchain technology applications. I think that's a wonderful background to start this discussion later. Ladies next, I'd like to introduce Anna Agu. She has extensive experience working for tax authorities and government working groups. Anna understands how vital the cooperation between innovation startups, government authorities, and legal expert is to provide the elaboration of innovation and technology in the supportive business environment. Since 2018, Anna advises companies in the field of cryptocurrency, compliance, and fintech regulation, specializing in the Estonian and EU regulation. And we're also a member of the Virtual Assets and Blockchain Working Group, who is working on the EU Virtual Assets Regulation communication with EU government authorities in 2020. So in the middle of those ladies, we have my friend from Germany, Frieda Backu, Munich-based lawyer. Frieda is partner with WHB, Witzel at Backu law firm, one of the leading firms in Germany in the field of information technology law. He's also a certified expert for tax law and for information technology law. He's consulting clients, international clients, since 2002, and represents them with respect to the businesses and activities in the German market. Of course, we as an IMGL member as well. And finally, last but not least, Andrius, well known in this area. Andrius is founding attorney of Gabnys.Gabniene, legal boutique based in Vilnius and in Tallinn. His father specialized in all legal fields of entertainment law, including gaming, of course, and technology, which is IT and cybersecurity. Andrius has been working in the online gaming sector for over 10 years and focuses on the multi-jurisdictional licensing and IP-related matters. Also a member of the IMGL. My name is Joerg Hofmann, and I have the pleasure to host this discussion. And since this is technically related, from time to time when I'm moderating these panels, I do something like bringing you back to your own memories to show you how fast technical or technological development is moving. If you try to remember the day when you received your first mobile phone, I think that was an exciting moment for all of us. Some of you are, fortunately, very young, so that status of that mobile phone, that development might be a very modern one. If I look back, it was a 92. And I show you my first mobile phone. It's this one. It's got a little channel. You bring it out. It looks like this. It's an Alcatel phone. I got it in September 93, I think it was, and I was proud, I can tell you, the hell of proud I was. What could you do with this phone? You could make phone calls. Who's using his phone for phone calls? Not everybody. And you could send text messages. That's it. The battery works for 1.5 hours. That's it. If you make calls, it would be less probably, but I was so proud. Imagine if you look at your phone now, iPhone, whatever it is, how different it is. We can sending videos around the world within seconds, sending photographs, can do video conferences. We can do so many things. We can surf the internet, and this is only within maybe 30 years. It's exactly 30 years. It's not a long term, but it is something where you can see how fast it's growing. Today, the technical development grows even faster. And here we are in the middle of our discussion to see that technology drives the industry, and regulation is always behind. So I'd like to start with you, Andrius, just from a generic approach. We're going to access this topic from a generic approach background, and then we deep dive into the details, in particular with the ladies bringing their expertise in play. So Andrius, what is happening in the gambling sector right now? Where are innovations taking place from the perspective of a gaming lawyer who is communicating with this industry and its stakeholders?
Thank you very much. So the voice is still there. It's a very nice phone. I remember not only the phone, but I think the fee, the price of a minute was quite impressive. To speak, to talk to. I can't remember how expensive the minute was there, if you remember.
Well, in these days there was no euro, it was German marks. Yes. In my country it was 1 mark 59 cents per minute.
Yeah.
So, so today
you have to speak fast. That's a good thing, and you have to speak. Yeah. Come home.
And the euro is 1.9 something. So, but today it would be the same price. Now it's cheaper, of course.
Yeah. Okay. So thank you for the question. The thing is that, with as a gambling lawyer, I always look at the gambling industry there's a concept, a category of creative industries. Nobody actually categorizes gambling as a creative industry, but I do, because for me, gambling is one of the most creative industries there is. Because if you don't, innovate in gambling, you're just out of the game, because everything's really changing fast, and the customers want new things and stuff. So as you correctly stated, the innovation is always faster than the regulation, because if it was the other way around, then the regulation would be called innovation. So the thing that I see as the key thing from a legal perspective, and not going very deep, not diving very deep into theoretical ideas of what should we do or not, is the legal principles, which is generally, what is generally accepted in the civil law. If it's not prohibited, it's allowed. While in administrative law or the public law, if it's not specifically allowed, it's prohibited. These general legal principles are key for to tackle the problems in terms of the regulated markets and innovation. Because here in the region, in the Baltics, it's very evident what works and what doesn't, because Lithuania and Latvia, they employ the administrative principle for gambling. If it's not specifically allowed, it's prohibited. Everything is prohibited if it's not specifically stated in the Gambling Act and the secondary legislation. While in Estonia, it's the other way around. Even though most probably it's not specifically stated that it's a civil thing, because it's an administrative public thing, gambling, because that's a regulated market. But in Estonia, the gambling framework is actually formed in the opposite direction. If it's not prohibited, it's allowed. And you think you can just call the regulator and ask, can I do that? And he will just answer, no, because it's, you can do it because it's not prohibited in the Gambling Act. So that's, when you tackle all the gambling-related innovation problems, this is the starting point, from my perspective, this is the starting point. Because when you have the principle of everything's prohibitive if it's not specifically allowed, you are always behind. While if you employ the principle of if it's not specifically prohibited, then it's allowed, you only have to, efficiently and react to the threats, because you're always going together with the innovation, because you're not, banning anything, while you just have to react to the, real threats and efficiently regulate those areas that you really want to tackle. So that's my 2 cents on the gambling and innovation, because gambling is not everything. There's AI, which is a separate thing, and there are many things that go separately, like individually, as concepts. But in terms of the regulated markets, because it's by definition regulated markets are regulated. They have regulation. They must have regulation because these are regulated markets. So the legal principles and the employment of legal principles are key. That's my 2 cents.
The issue is then that if regulation is behind, it's slowing down the process of applying innovation into this industry.
Yes, of course.
This raises the question what the goals of regulations are. What's the task, responsibility of regulators and regulation? Maybe from the perspective of the German, a very highly regulated market, at least most recently, what do you think what are the goals of regulation?
Well, thank you. Well, especially in Germany, we have seen a number of things which went wrong, and this can serve as example how you should not regulate the market. So, what is the goal of a regulation? If we look at it from a little bit of distance, from a high altitude, then we can see the goal should be that the regulation and the regulatory authorities, they build a framework for a market, with a stable framework for a market which enables the industry to survive in this market, which is accepted by the industry, which is accepted by the consumer. Because in the field of online models, in the internet world, you cannot regulate a topic like a restaurant, a local restaurant. It's an international business, and if the regulation is not established in a way that it is accepted, then the grey market or the black market will survive and will push forward, and the legal market will not be in a position to survive, and therefore it's also consumer protection. Consumers are not protected if they are left alone and are sent in the black market. And another topic is, without such a stable regulation, there is no innovation. Innovation takes place somewhere else in the world. We have the example of Malta, for instance. Malta established their laws in the year 2005, I think, and it attracted a whole industry which is now operating from there. Whereas we in Germany, we had industry in the early 2000 years, but it went away. So once again, a goal of regulation must be that it provides a stable environment which attracts the industry, and by doing so protects also the consumers and enables a working system in a long term.
as well as governments like the Baltics who support startups, who support innovation, young people coming up with ideas. You see how fast they're moving forward. We in Germany, which is a tech country, we are behind because our government does not understand that there must be some money on the table in order to support this. And I was really surprised. There's this bar in this Radisson Blue Hotel. You can order a coffee there, and they have a printing machine for coffee. So you can get a picture on the screen on the coffee. It's very modern, and other lovely tools to make things better, which are details only. But it shows that this is something where the details matter. I think that's very important. Anna, from your perspective of someone who's dealing with compliance all the time, compliance is, of course, a key word if we talk about regulation, about licensing, about supervision of gaming. What do you think is the challenges for the gaming industry now facing developments, facing new innovation? This could apply to gaming technology, this could apply to blockchain, AI, all these topics we raise, but also to payment service providers and to new channels of payments, including cryptocurrency, but everything else.
Thank you so much for this question. First of all, I would like to comment on the previous colleagues' remarks regarding the approach of the Estonian regulation regarding the gambling industry and communication with the supervisor. In Estonia, the supervisor there was like 3 supervising bodies for the gaming industry. First, and the main one who is issuing the licenses and tax and customs board. The second in regard to the money laundering is Financial Intelligence Unit. And then of course regarding the consumer protection, we have the special consumer protection board. So if we are talking about the approach of the tax and customs authorities, it has been changed like 10 or 12 years ago, when we had the new director of the Tax and Customs Board who said that we need to have the horizontal communication with our market players, and we would like to be as supportive government authority to the market players. And they are keep going with this approach. That means that, for example, if your taxes are not paid on time, you just get the kind email, and after you can get the kind call, and after they can call you and ask how we can support you by filling the tax declaration. And this is a small example how government authority can treat the market players.
Does it work? Are these people paying taxes after the third call comes in?
99% of Estonian taxes are paid on time online, and only 1% is what they are dealing with. And basically all others, the half of this 1% is paid after the call or email. So we basically do not have the tax steps. The similar situation is in Netherlands, but it's a very good sign of how good communication can actually establish the market growth. And another point that I wanted to add regarding the goal of the regulation, as we advise the companies all over the world since 2017, and mainly startups, technology companies, fintech companies, basically they are like competitive approach between countries. Why I should register my company, why I should register my startup, for example in Lithuania or Germany or Estonia, what is the advantage of your jurisdictions? And basically there are 3 main aspects that companies are taking into consideration. The first one, what about the banking access? The second one, what about the taxes? And the third one, what about the communication with the government authorities? And if those 3 points are met, the company is ready to establish, the company is ready to bring resources, human resources, financial resources to establish the business. So, starting to answer to your question, the challenges regarding the compliance, I believe that we still have a problem, especially in Estonia, with the banking access. It's not like a regulatory challenge, According to the regulation, the companies can open the bank account, but from the practical perspective, it's very hard, especially for the high-risk industry companies. And here we are talking about the gaming, gambling, fintech companies, crypto companies, all are having the same issues. And of course, there is a background. We have several IMGL scandals past years, and approach of Estonian banks is very intensive. So they are not ready to take any kind of risk, and they would like to avoid. But actually, for the market, it's a big problem because you're having the company in Estonia, but you need to look for the options of the banking in other countries, for example, Lithuania or even Germany or Switzerland. So it's the number one problem that I see. The second one is, of course, related with cross-border regulation and different cross-border approach. We do not have currency. We do have different licensing requirements and regulators approach. And I believe the third one that I would like to pay attention on is that sometimes we do not have this independent supervisory body who is having this competent knowledge to actually provide the good feedback, do the proper supervision, and advise the market players on the regulatory requirements.
I think it's a very good point to look at the dialogue between the industry and the regulators and all stakeholders. It's so important, the cross-border is important, learning from others' do's and don'ts. So probably regulators in some jurisdiction need to change their attitude, need to change their techniques. And you once said that regulators should not only adopt regulation as substance to innovation, you also said furthermore, there should be regulative techniques be innovated. Could you elaborate on that? What does it mean? What do we have to change?
I think what I meant by this was exactly this, that if technology changes so quickly that you've stated as well that regulation sort of lags behind, it means that technology is iterated constantly on a weekly basis, on a monthly basis. It changes. So it creates new challenges. In a similar way, regulation can be iterated. I think some examples can be also already seen at the European Union level, where the Media Freedom Act has a recommendation to different sort of form that is separate from the act, and that enters into force also immediately, but is not exactly part of the act, but it is a separate document, and it can be actually changed differently than the act itself, and act is a regulation. So it just shows that there have to be more fluid instruments introduced. And oftentimes, as we were discussing among some of the panelists yesterday, there are also solutions that the industry provides themselves. Like we have an experience in Estonia with crowdfunding regulation, where we did not introduce regulation when we saw platforms coming. We actually introduced something like a good guidelines or a sort of common guideline or common rules by the public-private partnership organization called Finance Estonia, and all of the crowdfunding platforms who wanted to show that they're actually not playing under the radar. They want to comply with rules and good market practice. They did come to Finance Estonia to get a badge that we are following these guidelines that you have introduced. So there are these organizations that we call self-regulating organizations that introduce either guidelines or standards or good governance rules, and you can show your good intentions, like as I was talking about in the previous panel as well. You can show your good intentions that I will do this in a positive way. I'm not a scammer, I'm not a fraudster. I want to do it in the way that like good companies with good rules and good governance are doing it. So I'm just merely stating that the regulated techniques can come from the industry itself, and they can come also from above, from the state legislators, from the local governments, and also from the European regional, like in different styles.
Thank you very much. Let's come to some practical examples. Maybe. You have researched blockchain technology regulation during your PhD. And what are the cases you've seen of blockchain technology in the gambling space? And is that innovation in any way been restricted by regulation?
Like we saw yesterday, there were some metaverses and NFTs, which is also kind of use of blockchain technology in the space of iGaming. I'm not sure whether there are any restrictions created other than like tokens and crypto in general are sort of negatively looked upon by the industry still. But I do think that various technologies, including blockchain, can help operators to follow compliance rules, like we were discussing in the panel also yesterday. There are some AI examples, there are some blockchain sort of activity log, like there is a startup called MChain that has been presenting in many iGaming conferences as well about their tool where you can log all of your compliance sort of actions. As recently UK Game Commission has issued really huge fines, and I've read some of these sort of coverage of the reasoning under the fines, for the basis of the fines, and they sort of use terminology like that certain compliance process wasn't escalated quick enough, or it wasn't reacted to quick enough. There was a sort of slow process, or they couldn't prove that something was escalated to another level. So I think MChain is sort of targeting exactly this with blockchain technology, that it's time-stamping everything that is happening. And what I mentioned also yesterday of sort of using AI in compliance and trying to figure out what exactly is the regulator expecting from you. You can feed it into the protocol, into your software, and then the software will keep alerting, reminding, and also logging all of the compliance procedures, and you can produce this log to the auditing, to the auditors, and prove that you have done everything as was required.
This is working on the basis of a timestamp technology, right?
Well, blockchain itself is timestamping of transactions. That is the idea of the technology.
Right. You mentioned these huge fines which were imposed recently. You can look at the UK, the Netherlands. Sometimes it is related to infringement of player protection requirements, of course, but it's also a very, very massive part of that is linked to AML. So AML, which is your field of practice as well, it's becoming more and more important. It always was important. What's your opinion on this? If you talk about compliance, AML, and new technologies, and also payment service providers, if we see this growing market, so many new names are on the market, so many new services are being rendered. Love to hear what you say about this.
Yes, so compliance in general is a hot topic last 2-3 years, but actually it was always important. From the statistic data, I have done a little bit of research, and there is a prediction according which within the next 5 years online gambling, for example, industry will grow 12-13%, which is quite huge growth. And if we're talking about online gambling or gaming, we are dealing with the technology. And if we have the technology and online possibilities to use the services, that we have this potential higher risk from the AML perspective. And of course, there are some kind of cases when we do have gaming involved in the money laundering scandals and gambling involved with the money laundering scandals, and this all affect the industry in general. From the regulatory perspective, I believe that we need to do the difference. We still do have in the European Union, to be honest, this grey market, the unregulated gambling service providers, and we do have regulated gambling service providers and gaming service providers. And I believe the big difference between them is 100%. If we're talking about the regulated markets, they do understand that they are obligated entities according to the annual regulation, and they need to have the risk-based approach, and they need to have the due diligence measures, verify the clients, and fulfill all the rules. However, the compliance regulation is tightening. We do have regulation, and then we have the guidances. We do have the guidances provided by FAT, for example. We need to also take into consideration. So it's a very intensive very intensive duty for the market players in financial industry, gaming industry, gambling industry, to actually be compliant fully. And sometimes you do not have even the clean understanding, can I do it like this or no? For example, in Estonia, regulation in 2022 changed regarding the online verification of the clients, and there is a specific ministry ruling which says which kind of technical and regulatory requirements should be met when you are doing online verification of the client, online interview with the client. And there was a lot of clauses regarding there should be the timestamp, there should be the such kind of technology tools behind, you need to do this, this and this. But from the practical perspective, it's too hard to follow this. And for the market players to implement this online interview face-to-face when you are asking the question directly from the client. So a lot of companies decided, I will take this risk and I will do only liveness check, for example. But it's not enough, actually, according to the regulation. It should be online face-to-face interview. So yes, such kind of problems when regulation, the idea of the regulation is good. We want to prevent the money laundering, but we have so tight rules, which is actually hard to comply with. So this is the main point, I believe, that we should try to avoid.
Because that's a great challenge, the speed of regulation, the scope of regulation. Can it always be 100%? I think it can't, because something new is happening all the time. Either are we over-regulated or are we too slow in regulation? What is the balance for good regulation, and what is the consequence of good or bad regulation?
Well, I think that we in Europe rather have the tendency of over-regulating things. Let's take the example of GDPR. It has been established and implemented in all of Europe. Nevertheless, it is applied in a different way in many member states. It was drafted to regulate the market, to protect consumers, to try to establish European entities instead of these big Facebooks and other operators. And if we look at it now, we can ask, has this goal been achieved? One goal has been achieved. It created a lot of work for us lawyers. It was not so bad, but this should not be the goal of regulation. So it created a lot of compliance work for the industry without really changing the situation to the benefit of all involved parties. So this is an example. And now we are seeing the digital strategy of the European Commission. There is a number of laws which now has to be implemented by many industries, and it once again will create even more work as GDPR for lawyers, for the industry. And for example, now the Artificial Intelligence Act has been released, or a draft of it, in April. It includes 85 articles. The draft is on 108 pages, and once again, it is a very, very intensive regulation. And the question is, will this support the European industry of artificial intelligence, or will the industry say, well, this is not the environment where we want to be in. We go to Asia, we go to Dubai, we go to United States, we go wherever, but we do not go to Europe. And so investments, and here huge investments are necessary, they will take place in other parts. So my concern really is that there is, in the gaming industry, and it might happen in all other industries as well, there is a tendency of over-regulating things. And we are, in Germany, we are the best example. We are intensively regulated. Communication is unclear with the authorities. The restrictions are high, and the taxes are the highest in Europe, maybe the highest in the world, with a 5.3% on the stakes for slots. So how can this industry, the legal industry, survive under these circumstances? Or isn't it rather so that the black market will be supported by this legislation? So I really have the concern that we could do better in Europe and in many member states by not going into much detail, over-regulating things, establishing technical guidelines which are already old when they are published. This does not make sense in these new technologies.
I think it's a good point that regulation that is not too much going into the details, more generic, offers more flexibility in following up with new developments, and not just setting a status which may be outdated in a few weeks, months, years, whatever. You were all distinguishing between licensed and non-licensed activities, offerings, black market and licensed market. One thing they both have in common is that no casino, no online gaming would work if there's no payment service provided between the players, the punters, and the casinos, the operators. And this, of course, applies to black market and to licensed operators. If I were a black market operator, I can do whatever I want because I don't care about regulation. It's a high level of competitiveness that is taken away from the licensed market. Andrius, how important would you assess the role of payment service providers if you look at these two different levels, regulated and unregulated, probably being subject to enforcement, but being existing. And here new technologies play a very specific role and is not part of regulation.
Okay, so yeah, obviously that's a good point. That's more or less a self-regulatory framework that you referred to, because that's if you go through some sort of a level of thoroughness and risk assessment by another market player which is not regulated itself. So that's a very good point, and it already employs some self-regulatory framework between two or multiple industries within that framework. So yeah, I totally agree, but that's already not a regulatory side, but the segments of regulation like AML, let's say. So that's something that you must comply with, but not in terms of innovation as such, because in this perspective that you're asking, I don't think that the crucial part is innovation. It's just that it's licensed or unlicensed. It's regulating. It's targeting. Some jurisdictions which they can't target or not, but not specifically, innovation. Why I'm referring to that, and that's the first principle I was referring, when I started. I think I was the first to speak about the legal principle of everything is allowed until it's prohibited. So that's what the thing I would agree with myself. And the other thing is that when we think and we speak about innovation, we don't really, we shouldn't always look at the regulation or regulator as the victim of fast-changing world, because right now, even these conferences have this trendy thing called RegTech or GovTech. What's the name? I think RegTech or GovTech, where the regulation or the regulators go into offense rather than defense. They employ innovation by regulation. Basically, there was a good point that you referred to, is the identification and verification of the player. So basically, prior to that, no innovation was there. You just submit a scan of an ID and a utility bill. There's no innovation there. Then there's the regulator who came up with the innovation, and you just now everybody has to employ some innovative measures, automated tools like the scan of the face, the scan of the ID document, which is already where the regulation is going into offense by employing the innovation. There are many these kind of examples when, let's say, the industry is they are lagging behind not only the industry but the customers as well. Let's say in Estonia, there's a requirement for the gambling industry to integrate platform into the tax authorities. There's a protocol called X-Road protocol, the data communication protocol, which is actually an innovation, which is driven by regulation, not by the industry. So I was just sitting and thinking, why we always think of regulation and regulators as the victims. Sometimes it's the other way around. So but to that point that you were referring to, when the PSPs are employed, from my perspective, it's a self-regulatory framework. So it's managing risks in between multiple industries, because PSPs are not gambling, but they facilitate gambling. So, and it's not always innovation driven. Sometimes it's just like, taking on the risk or not. So that's my 2 cents.
Yeah, good point, thank you. So things are prohibited or things are allowed, but one has to make a decision. Someone has to make a decision whether it's allowed or whether it is prohibited. And what do you think is the best time for regulation or regulators to pay attention to new developments? Should it be at a rather early stage, or should they wait until there's more experience? Should they regulate at all? Many things. What do you think is the best approach to deal with these issues?
To bring a few examples, I think when Bitcoin first hit the market, and then a lot of interesting things started to happen, including the DAO, the original, the DAO that raised money through sales of tokens and then planned to invest the money. I actually quite enjoyed the US Security Exchange Council Commission doing an analysis of the DAO after it died. So after Ethereum blockchain forked and actually became like 2 different chains. What it showed was that the regulator waited and it observed and then did an analysis and then reacted and showed that, okay, this is how we feel about this, what happened, and this is how we would regulate, or this is how we would enforce against any similar actions. At similar time, or actually like a few years earlier, there was a case in Estonia where the regulator acted quite differently in the blockchain space. I followed this in my PhD research, where I sort of looked at the media coverage on Bitcoin, or any cryptocurrencies, and all of the state officials who took any kind of stand in the media were saying that it's unregulated, using the word unregulated. They try to warn the consumer, stating that do not get involved because you don't have any protection, right? But at the same time, this message of unregulation also went to the entrepreneurs or the early adopters. They were also convinced it's unregulated, so I don't have to follow regulation because there's none that applies to me. That was not true. So what the government also decided, or actually the enforcement started from the FIU, was that the FIU said, no, but the AML rules apply to you equally as to others. And if you think about AML rules, we haven't discussed this here, but it is actually selected companies and individuals doing the work of the governments. The governments are the ones who want to find the money launderers. So there is a selected group of companies, including gambling operators and lawyers, for example, and notaries, who have to do a certain AML due diligence. So what the FIU did in the case of this early Bitcoin exchange operator was that they sent them a letter and saying, although all of the media coverage has been that it's unregulated, it actually is regulated and you should follow AML rules. Have you done so? So what I'm saying with these examples is exactly this, that if the state officials figure out that something falls under regulation that is innovative, new technology, never been done before, they should also start sort of discussing this by public communication, by explaining, by training, by communicating, as was said earlier, not by enforcing first. And this is how, even if there isn't a specific targeted regulation for this new technology, AI also falls under regulation. As was discussed yesterday in some of the panels regarding AI, the US, for example, took a stand that they didn't want to regulate until the industry themselves sort of said, oh guys, there's so many risks involved. Like halt the adoption before there is actually regulation. Sometimes the industry themselves, once, like Astra was discussing in the earlier panel, wants there to be regulation for the industry to be stable, wants there regulation to protect the ones who want to follow the rules. So sometimes the regulation has to wait until the regulator actually understands what's going on the market. Sometimes there has to be victims and a whole lot of money lost before we know exactly where is the pain point that we need to regulate.
Well, that's very insightful. Thank you so much. I have two topics which I'd like to discuss finally with you. First one is learning from you, means that the industry needs to be compliant, of course, if there's regulation being developed further, but they also have to become compliant from step to step. From your perspective, what is your advice? How can the industry be compliant? How can they get further level of compliance?
Of course, we can talk about this topic for hours, or it can be a separate conference, so it's a very wide question. And everything starts from the right mindset, I will say. If the mindset of the founders or the managers of the company is proactive and having the clear understanding that we are obligated entity, we need to comply, we need to understand regulation, we need to do our best, and then it's actually already the good beginning. But from the real tips or real suggestion what to pay attention to, first of all, if we are talking about partners, especially if we are talking about KYC, KYT, KYB providers, you need to have the good technology, you need to have the compliant partners, you need to do due diligence on those partners if they meet the requirements that are actually applied to you according to the law. The next one is processing companies and processing partners. We a little bit touched this topic. I can see and I can confirm that from the practical point, last 2 years we see a lot of collaboration between cryptocurrency service providers and gaming industry or gaming industry, and a lot of, for example, gaming companies are using crypto as a payment method. And here also we have the problem when if you are regulated, you need to use already regulated crypto payment service providers, and not all countries in the EU are regulating such industries. So you need to pay attention on this. The third point that I would like to say is that you need to follow not only the regulation but also the guidances provided by the regulator and organizations. And last but not least, you need to have very personalized documents, IMO documents, like copy-pasting, taking some kind of general rules is not helping. You need to have the risk-based approach, which is dedicated to the directly company business model and business description.
Thank you very much. And finally, if there is regulation, it will only be applied by those who are compliant. And then there is the black market, without any breach of regulation targets. So I think this is a question for a German lawyer. A gaming regulator provides regulation, provides requirements, rules, standards, issuing licenses within 3-year conditions, hundreds of conditions probably. But on the other hand, they also have to look at the black market to protect the compliance business, finally to protect the consumer, the player. And this can not only be done by interdictions and rules, it can also be achieved by enforcement. How important and how successful can enforcement be to protect the compliant market?
Well, to the extent that there is a stable legal environment, enforcement and compliance is a very crucial part of a regulation. Because it's like kind of reputation management of a regulation. A regulation can only survive in the long term if the rules, the clear and transparent rules which have been implemented are really complied with, are audited and supervised. Otherwise, it is just a question of time until things like what did we have? Full tilt, the license of full tilt, for example. It's a long time, not all of you will know that, but there has been a kind of crash with the operator. Money was lost, and so for the licensing system, it was very clear that this licensing system did not work. So, as mentioned, it's just a question of time until things go wrong if they are not supervised. So, having good regulation requires its supervision. And if the regulation is bad and too strict, and is then being supervised, it of course causes problems, because the licensed operators, they cannot comply with all the rules. It's too complicated or unclear, so they will fail. There will be court proceedings, trouble. We lawyers are once again appointed, and it does not really work, so this has to be avoided. So 2 principles: clear, good regulation, and a proper and strict supervision and compliance of it.
It's so easy, as you said. Do you have any questions, by the way? Then now it's the time to raise them. Yes, please. Sir.
Just like...
Microphone is coming. It's just in the middle, to your left.
It's a very interesting panel, guys. Thanks for your insight.
Thank you.
I would like to hear all of your opinions. Every conference I tend to go to, the topic of channelization is constantly popping up. very interested to hear your thoughts on solutions to actually combat unlicensed operators or the black market. And what I would like to propose or hear your thoughts around would be using evaluated gambling blocking software, blocking through internet service providers and at a DNS level to eradicate unlicensed operators. What are your thoughts on that?
Okay, so you addressed this question to all of us, and I think it's a very good closing question for this panel. We start with you, and follow up, and I'll be the latest and the last one to comment on this. Please, no longer than 1 minute each.
Hi, you took my microphone. Okay, so yeah, so the question is, what are the good measures of blocking, of fighting the black market? Is that correct? What are our thoughts on what's okay? So this is something that that has been discussed everywhere. So right now the general approach is to have a dual, let's say, dual blocking measures, payment blocking measures, and the domain blocking measures. So everybody knows that with the domain blocking measures, it's a bit of a I don't know, it's how to call it. It's not working well. So the payment blocking measures are those which are more or less tackling the problem more. What we have in, let's say, in Lithuania, we have a big mess with the payment blocking measures, because the worst thing with that is what Frida told. You prior to employing a regulation, you must, the regulator must understand what he's actually doing. So what's done in Lithuania is that all of the payments of the blocked operator are basically blocked. So if an operator is buying a table in Lithuania, he can't actually pay for that table. So if an operator employs 2 developers, that operator cannot pay for the salary to those developers. Yeah, sorry.
It's becoming a very long minute.
Yeah, sorry. So yeah, so I suppose prior to employing these kind of regulatory measures, the regulator must understand how it works, and then to understand how to answer the questions that the operators are asking or the industry are asking. Because right now there are the majority of the industry, of the jurisdictions, they can't really answer what they have actually implemented in the legislation. So sorry.
I thank you for this question. This is an amazing question, and I'm more entrepreneurial as a lawyer, and I always want to focus on the solution, not only talking about the problem. So I would like to say that you need, it's from the government perspective. Government authorities, lawmakers need to sell the idea of being regulated will bring you the benefits. And this is what happens in Estonia with the crypto industry. There was a lot of coverage in the social media about why you should be regulated, what it will give you. It will give you consumer protection. You will be having the possibility to have the round tables with the lawmakers. You will be regulated, you can split well. You will be not fined, etc., etc. So you need to sell it. You need to sell this idea of being regulated is a good idea.
Well, I think I share this view. I also think it's much more important to have good regulation, good communication, transparent communication between the regulator and the industry, because then the industry is fighting itself against unlicensed operators. So the market mechanisms are being put in place. The best product survives. So first of all, this is required, a good regulation, and then it can be supported by IP blocking and by payment blocking, whatever measures. But First of all, it must be a good system. And because otherwise, if you take it vice versa, the people will always find possibilities to circumvent any blocking mechanisms. Those who want to play, and these are at the same times those we would like to protect. Those who want to play will find their way to a provider somewhere in the world, and this will not be possible to completely stop this. So the aim must always be having a high regulatory rate by a good system supported by some additional measures, not vice versa.
Yeah, I think pretty much everything has been said. As Andrius was saying at the start, it's a creative industry, which means that if the regulators or enforcement is creative, then the operators of the black market are also creative in going over those blockers. But as was said by Greta, if there is incentives for the players to actually use regulated operators, more than the black market, if we allow maybe more selection and more flavors into the regulated operating and not so many limitations, then maybe they don't seek the thrill in the black market.
I can't agree more with you. And then final remark from my side, it's a personal opinion on channelization, because it's all about player protection, and you can only protect players in the environment where the player is playing, and the player decides where he's going to play. If there's something more attractive outside of the regulated market, he decides in favor of the black market offerings. And apart from these technical tools like IP blocking, payment blocking, which you also do in Germany from time to time, I don't think this is really the key for successful regulation. The key is making the license offerings competitive, allowing players to find what they are looking for. What is the difference between the offerings of black market operators and those restricted license operators? This is the case. We need to analyze this and make this better. There was one example in history across the European Union, that was in Italy. Italy started to introduce a very restrictive online gaming regulation in the beginning. After a few years, they realized that's the wrong way. We lost all of our traffic to black market operations. They changed regulation and they customized it more to the demands of the players, and overnight those lost players came back. And that's something which our regulators need to learn. We do IP blocking, we do payment blocking, and the established payment service providers are going either out of the market or are limited to license operators, which are not many. But payment transfer happens. It's just easy. And this is why we are talking about new technologies, talking about ledger technologies, cryptocurrency. It works. And as long as I cannot achieve any successes here, I need to look at the other end and try to improve the offerings and remove the reductions, including the highest taxes. With that, I'd like to thank my panelists for their excellent contributions, for your attentions and questions, Zoltan for bringing this all together, organizing this conference so brilliantly, and being a great host, excellent. Well, that's the Andrius Masterclass for this conference. Thank you very much, and hope to see you soon again.
Thank you, Joerg.